committee stage.
I declare the House in committee for consideration of the Court's Remote Participation Bill. Mr. Chairman.
The House and Committee on the Court's Remote Participation Bill. The question is...
Point of order.
Point of order, Chris Tremaine.
Point of order, Mr Chair. I seek leave for the committee stage of the Court's Remote Participation Bill to be debated as one question with multiple calls.
Leave is sought for that purpose. Is there anyone opposed to that course of action?
By multiple, you mean unlimited?
Unlimited.
Thank you.
Everybody clear? And no one's opposed to the leave. Leave is granted. I'll just read the question then, which it now is. The House and Committee on a Court... Right. The question is that parts 1 and 2 and clauses 1 and 2 stand part. Some member seeking the call. Honourable David Parker.
Thank you, Mr Chairman.
I shall go.
Can I first say that I'm a wee bit disappointed that this has been brought through to committee stage today. I actually think that this is one of these bills which, because it abrogates a civil liberty that we all currently enjoy, it would have been better for the government to actually bring something else up on the order paper. This just had its second reading yesterday, and I actually think it would have been a good idea for the government to take a breath on this and actually have a think about the issues that the opposition has been raising. This is a serious issue, Mr Williamson. You and I and everyone else in New Zealand currently has the right to attend the trial if we are accused of a crime. And this bill makes that right conditional, and that a judge can exercise a discretion to conduct a substantive hearing without the accused being present. Mr Bridges yesterday said that he thought the opposition was over-egging it and made reference to some cases where he said this already happens. And I thank Mr Bridges for his efforts, and I read the reference to the cases that he forwarded that came from Adams on criminal law. The cases that he referred to were where the accused was deliberately absenting himself or herself from the trial. Quite different, quite different. What's being proposed here is where the accused wants to attend the trial, there will still be a discretion to the judge to disallow that appearance. There is no good public policy reason for that. I would ask the Minister, as I asked the Minister yesterday, to give us an example of where there is a problem that needs to be cured. This is curing an illusory problem. There isn't a problem with the current system. All parties in this House agree that using audiovisual links for bail applications or adjournments can be appropriate in some cases where the defendant or the accused does not agree. But where the opposition parties, including the Greens and Labour, disagree is in respect of a substantive hearing. And I want the Minister to say why he thinks it's justified that an accused is going to lose the automatic right to face their accuser. Think of how that is relevant. If I'm the accused and the main witness for the prosecution has to stare at me contemplating perjury while with the consequences that would be my imprisonment, they might be a bit more edgy if the accused is standing there in front of them. And that edginess would reflect in the weight or the truthfulness that the judge or the jury would find in respect of that evidence. That is something, that right of the accused to have that effect on witnesses ought not to be taken away from the accused in any situation. Similarly, Mr Chairman, other things can go wrong in a court that the accused has got a right to see. Who on the jury is falling asleep? Did the judge fall asleep? Is there a cosy relationship between the lawyer who's acting for the accused and the prosecution? Is that relationship so cosy that the accused doesn't feel his or her interests are being properly represented? What about the case of accused that wants to personally conduct his or her case? What about the case where the accused halfway through a trial might want to dump his or her lawyer and personally represent themselves in the case? What about the case where someone sitting in the gallery starts to wave a sign around that's prejudicial to the interests of the accused? The accused won't be there to see it. There'll be one camera, and the accused will never know it's happened. What about the accused who's sitting in a prison somewhere on the end of an audio-visual link who has to put up with interference from prison guards? That'll happen sometimes too, at least possibly. All of these things are theoretical possibilities which show that an injustice can come as a consequence of us abrogating the unconditional right that someone currently has to attend their own trial. Now, that right is unconditional, and they've got a right to be there unless they abuse the privilege at present. If they abuse the privilege and they start interfering in the court process, of course the court's already got the right, Mr. Chairman, that has already got the right to Mr. Chairman.
The Honourable David Parker.
Of course, the judge has always got the right to control his or her court. If someone acts in contempt of the process, they can be stood down, they can be sent to the cells, they can be locked up, they can be imprisoned. But that's a situation where the defendant or the accused is there and abusing the process. That's not what we're talking about here. We're talking about giving a discretion here to the judge to allow a trial of an accused in a substantive criminal matter who could be facing a very long term of imprisonment not to have the right to be present at their own trial. And that's what the Law Society object to, that's what the Human Rights Commission object to, and that's what the Labour Party objects to. And I hope, Mr Garrett, from ACT, that you're reflecting upon this, because this is a basic civil liberty to face your accuser. This can be so easily fixed by agreeing to a supplementary order paper that's in my name, and there's a similar one from Kennedy Graham, which says that this discretion to have a trial in the absence of the accused should not ever be used without the consent of the accused. If the accused consents, well, that's fine, but without the consent of the accused in a substantive criminal matter. I'm even a bit nervous about that being able to be done in appeals. Well, I can't fix that in this legislation, but certainly on a substantive matter, I cannot see the justification. This has been a civil liberty that has been in existence for centuries. The right of an accused to face their accuser, the right for the trial to take place in their presence. There was no evidence at Select Committee of there being a problem here that needs to be fixed. This, with respect to officials, is a mistake that has come out of the Ministry of Justice, who have confused the need for administrative efficiency and cost effectiveness in respect of interlocutory matters, call-overs, bail applications, and they've allowed that interest to outweigh what I think should be an unconditional right to attend one's own hearing. Can I say that I'm dismayed that the Department of Justice found that this didn't even breach the Bill of Rights. The Bill of Rights says that one of our basic freedoms is the right to attend our trial. Not the right to appear at a trial via video conference, but the right to attend a trial. And somehow the Attorney General, on advice, has found that that doesn't breach the Bill of Rights and it didn't require a Bill of Rights vet. I'm astounded by that. I really am astounded by that. So, Mr Chairman, I ask the Minister to take a call in response to this issue. I cannot see the justification for this in respect of substantive matters. These aren't matters of politics. In fact, we voted in favour of this bill at the first reading. It wasn't until we got to Select Committee and realised it was going to apply to substantive criminal matters that we saw the problem. And I would have hoped that this is an area where you wouldn't erode civil liberties lightly, and that where the Law Society, the Human Rights Commission and the opposition are saying, look, this is wrong, where this is going to be applied in 99% of the cases is right, let's just leave out these 1% of the cases where it might be applied. It's just wrong. It is bad law. I feel that this is a serious incursion into civil liberties. There are better judges and there are poorer judges. There are times when judges